Good afternoon, and thank you for joining the Federalist Society at the University of Virginia School of Law for our third annual Originalism Symposium. My name is Connor Kurtz, and I'm the Symposium Chairman of our school's Federalist Society chapter. If you've been with us all day, welcome back, and if you're just joining us now, welcome. I'm honored to introduce the members of our final panel, Originalism's Public Meaning. Evan Bernick is our moderator. Professor Bernick is a visiting professor of law at Georgetown University Law Center. He was formerly a clerk for Judge Diane Sykes of the United States Court of Appeals for the Seventh Circuit. His scholarship focuses on constitutional interpretation and administrative law. He has published with the Georgetown Law Review, the William and Mary Law Review, and the George Mason Law Review, among other journals. He received his JD from the University of Chicago Law School in 2011, and he graduated with honors from the University of Chicago in 2008. Kurt Lash is a professor at the University of Richmond, where he teaches constitutional law and leads the Richmond program on the American Constitution. Professor Lash has published widely on the subjects of constitutional history, theory, and law, and he is currently working on a 2-volume collection of original documents relating to the framing and ratification of the 13th, 14th, and 15th Amendments. Professor Lash's work has appeared in many legal journals, including the Stanford Law Journal, Georgetown Law Journal, Virginia Law Review, and Notre Dame Law Review. He has been a visiting professor at Northwestern University School of Law and is the former director of the University of Illinois College of Law program in constitutional theory, history, and law. David Latt founded Above the Law, one of the nation's most widely read legal news websites, and he now writes a newsletter on Substack about law and legal affairs. That newsletter is called Original Jurisdiction. His writing has also appeared in the New York Times, Washington Post, and Wall Street Journal, among other publications. He previously worked as a federal prosecutor in Newark, New Jersey, and as a litigation associate at Wachtell, Lipton, Rosen, and Katz in New York, and as a law clerk to Judge Diarmuid O'Scanlan of the U.S. Court of Appeals for the Ninth Circuit. He graduated from Harvard College and Yale Law School, where he served as an editor of the Yale Law Journal. Elizabeth Slattery is a senior legal fellow and deputy director of the Pacific Legal Foundation's Center for the Separation of Powers. Ms. Slattery has written for the Harvard Journal of Law and Public Policy, the Cato Supreme Court Review, and the Federalist Society Review, among other publications. Her opinion pieces have appeared in the Wall Street Journal, the Washington Post, SCOTUS blog, National Review Online, and many other outlets. She has testified before Congress and is a frequent legal commentator in print and on radio and television. She's a graduate of Xavier University and George Mason University's Antonin Scalia Law School. Thank you to our panelists for joining us this afternoon, and thanks to you, the audience, for joining us at this symposium. And with that, Professor Bernick.
Sorry about that. Thank you for that introduction, Connor, and thank you to UVA FedSoc for inviting me to moderate this panel. And thanks to those of you in the audience, particularly those who have borne with us for several hours worth of originalism today. I'm excited to be here with such a distinguished group of originalist experts to talk about originalism. I'm planning to just give a 5 to 7 minute introduction, and then, as has been the process throughout the day, we'll plan to go around and do about 10 minutes worth of panel discussion, and then general discussion, and move on to your questions. Originalism is mainstream. So declared Professor Lawrence Solem, testifying at the confirmation hearing of then Judge, now Justice Neil Gorsuch. What he meant was that originalism is now part of the normal science of constitutional interpretation in the academy and the ordinary practice of constitutional law in the courts. Scholars, judges, lawyers to varying degrees make and respond to arguments from original meaning, and virtually no one within the legal community publicly takes the position that original meaning should be outright ignored. Entire areas of constitutional law at least begin with original meaning, and there are now 6 justices on the Supreme Court, solid majority, that are, let's say, originalism friendly. Not all of them identify as originalists, but 4, sometimes 5 of them do, and the other 1 or 2 will go there if invited. Now, on one influential account of what law is, the positivism of H.L.A. Hart, This convergence upon originalism may be enough to make originalism our law, as Professor Steve Sachs has put it. And yet Hart's account is pretty hierarchical, even elitist. Widespread, stable legal practice and the internal points of view of those who participate in that practice make law. What ordinary people who are subject to the coercive apparatus of the state think the law isn't part of the equation. It's a separate issue. And yet it's an important issue because, as we all know, the judiciary has neither sword nor purse. An interpretive regime that rested solely upon lawyerly consensus as to its value would be less than stable. Which is why originalists cannot ignore, even if they might like to, missives against their methodology of choice that are issued by leaders of public opinion. I can think of no better example of this than the scathing essay published in that magazine of record, Cosmopolitan, on March 21st, 2017, entitled 9 Reasons Constitutional Originalism is BS. 9 reasons. It is something of a miracle that Justice Gorsuch was confirmed in the face of this criticism. Now, I'm not being entirely serious, and yet there are compelling reasons to make the case for originalism to the public despite originalism's official hegemony. One of the longest standing normative arguments in favor of originalism is a democratic one, grounded in popular sovereignty. It would be a bad look for originalists who make those arguments to disregard popular dissatisfaction with originalism. Then there's the matter of truth. Truth is worth defending, and many claims about originalism that were advanced during the Gorsuch and more recently the Barrett hearings just aren't true. They deserve a response for that reason alone. Finally, the court itself may need originalism. Compared to the public opinion of the other branches of government, the court pulls pretty well, really well. But that's not saying very much. And recently, public opinion has been declining. As Professor Tara Lee Grove has shown, certain norms that preserve judicial independence are more fragile than we might think. We take it for granted, for instance, that political actors will not tinker with the Supreme Court's size in order to pack it with like-minded justices. But these norms are of relatively recent vintage, and recent polls show striking levels of support for court-curbing measures. Is there anything that the court itself can methodologically do to keep judges within the bounds of the law? An enduring defense of originalism is that it has a unique capacity to keep judges within the bounds of the law from which they derive such legitimacy as they possess. And if that's right, the court may need originalism for the sake of its own continued independence, which independence is still generally deemed to be a valuable thing. Now, I have this distinct pleasure of moderating a panel composed of experts that are deeply versed in originalism, who take concerns about originalism's legitimacy, its relationship to the legitimacy of the Supreme Court seriously. I've thought extensively about how to respond to it. And with that, I'll hand things over to Professor Kurt Lash to give opening remarks.
All right, well, thank you, Evan. I hope that my microphone is on. I generally forget to turn it on, and my students have to remind me. It's a pleasure to be here, and kudos to Virginia for putting on this conference about the many splendored thing known as originalism. And it's such a privilege to be here. I'll talk a little bit about the general public and the history of public acceptance of originalism, and then I'm happy to turn it over to my fellow panelists. Now, it's interesting that Evan just brought up public opinion leaders, and it reminds me that there really is a divide between academic discourse and elite discourse regarding originalism and the general public's view of originalism. Originalists, of course, continue to remain a minority in the academy. I think if you polled the faculties of the top 10 law schools, really top 50, top 100 law schools, I think you find that most academics believe that originalism is impossible, or that it's incoherent or undefinable, or that it's a smokescreen for conservative judicial activism, or all the above. And media elites, I think, generally echo this same idea, not just Cosmopolitan, as Evan has quoted from, but try Googling. I mean, right now, while I'm talking, try Googling the New York Times and the term originalism, and you'll quickly find out what I mean about media elite criticism of that particular methodology. But this panel isn't about them. This panel is not about academic discourse or the views of the editorial staff of the New York Times. We've been asked to address the views of the general public, and those views, I think, are very different. I think the general public is supportive, broadly supportive, of originalist interpretations of the Constitution, and that's why the New York Times and academic critics spend so much time trying to convince the average American that originalism is actually a terrible idea. One way I think that you can tell that originalism, despite this criticism, has such broad public acceptance is by listening to judges and to lawyers and to politicians discussing any hotly debated constitutional topic. Everyone, regardless of their political orientation, tries to occupy what they believe is the high ground of claiming their view is consistent with the original understanding of the Constitution. In just the last couple of weeks, for example, I can't count the number of essays and articles explaining why impeaching a private citizen who no longer holds office is perfectly consistent with the historical understanding of the Constitution. Now, of course, same kind of originalist argument is used by those opposing impeachment. They have their own essays and their own blog posts explaining why impeachment and convicting a private citizen and barring them from future office is absolutely inconsistent with the original meaning of the Constitution. It's as if all sides in this major constitutional debate recognize the presumptive legitimacy of grounding one's interpretation of the Constitution on its historical understanding, and they anticipate the general public's acceptance and in fact, the general public's support and demand for a historically grounded interpretation of the Constitution. Now, it's possible that one reason for current general public acceptance of originalism is due to the hard work of originalist theorists over the past few decades as they responded to criticisms and they refined and they clarified the theoretical moving parts of originalism. And I'm sorry that Larry Solom isn't here because he deserves a lot of credit, I think, in moving that theoretical ball forward. But as helpful as his and other scholars' work has been, I think, in fact, the public's presumptive acceptance of following the original meaning of the text is nothing new at all. Consider, for example, the testimony of now Justice Amy Coney Barrett on the second day of her hearing before the Senate. Then Judge Barrett was asked to define in English the meaning of the legal concept of originalism. And Judge Barrett responded, quote, "In English, this means that I interpret the Constitution as law and that I interpret its text as text, and I understand it to have the meaning that it had at the time the people ratified it." Now, Justice Barrett's definition echoes the same idea that was communicated by James Madison back at the time of the founding. In 1791, even before we had ratified the Bill of Rights, Madison insisted that in order to properly interpret the Constitution, Congress had to look at the original understanding of the ratifiers in the state conventions. And in 1796, Madison explicitly developed the distinction, one that we've worked on in scholarship so recently. He developed the distinction between following the original intentions of the framers and the original understanding of the ratifiers. In a speech before the House, Madison explained, and I quote, "Whatever veneration might be entertained for the body of men who formed our Constitution, the sense of that body could never be regarded as the auricular guide in expounding the Constitution. As the instrument came from them, it was nothing more than the draft of a plan, nothing but a dead letter, until life and validity were breathed into it by the voice of the people speaking through the several state conventions. If we were to look, therefore, for the meaning of the instrument beyond the face of the instrument, we must look for it, not in the General Convention, which proposed, but in the state conventions, which accepted and ratified the Constitution." That's in 1796. And it's the same theory that Justice Barrett used in her confirmation hearing. And in between 1796 and 2020 are countless similar high-profile examples of lawyers and judges and politicians making constitutional arguments that all assume the general public supported a historically rooted interpretation of the Constitution. The constitutional debate over slavery, for example, was largely a debate over the original meaning of the Constitution, with Calhoun and Taney insisting that we should follow the original intentions of the framers, and Frederick Douglass and Joel Tiffany and Abraham Lincoln insisting that we should follow the original meaning of the text, and slavery was not in the text. The general public in the North, of course, cast their lot with Douglass and Lincoln, and it is to them that we're indebted for the 3 Reconstruction Amendments. first-year law students learn other examples from the antebellum period when they read John Marshall's opinions in McCulloch against Maryland and Barron against Baltimore. Both opinions are based on Marshall's conclusions about the original public understanding of the Constitution. In McCulloch, Marshall reminds readers, of course, it's a constitution we're expounding and the document must be read flexibly to allow Congress to respond to future crises. But those interpretive conclusions were based on Marshall's previous description of the people's understanding who ratified the Constitution and the historical understanding that its terms had to have from the very beginning. Whether Marshall himself was an originalist is, of course, an interesting question, but it's clear that he anticipated that his audience demanded such an approach. Academics or critics will sometimes point to the legal tender cases or Blaisdell in the 20th century as non-originalist opinions, but the overwhelming thrust of judicial opinions from the founding to the current Supreme Court is one that relies on the presumptive legitimacy of grounding constitutional meaning on the historical understanding of the text. And even the least originalist justice of the modern era, Anthony Kennedy, understood this. In Lawrence against Texas, Kennedy insisted that his reading was consistent with those who originally, quote, ratified the due process clauses of the 5th and 14th Amendments. There's a reason, in other words, why Justice Kagan, during her confirmation hearing, found it prudent to declare that sometimes the framers laid down very specific rules, sometimes they laid down broad principles. Either way, we apply what they say, what they meant to do. And in that sense, we are all originalists. Kagan's appointment is followed by that of Neil Gorsuch, an avowed originalist and one whose appointment suggested to Lawrence Solom that a new gestalt might be on the horizon regarding originalism in constitutional discourse. Justice Barrett's open embrace of originalism, I think, clinches the matter. Originalism's critics have simply failed to convince America that originalism is a bad idea. They failed, I think, because most Americans refuse to give up on the idea of popular sovereignty, the idea that the people themselves can constrain the powers of government, including constraining the powers of the federal courts. And that idea, popular sovereignty, is necessarily originalist. The people's declared will continues until such time as the people alter or amend their constitution. Or put another way, the Constitution is not the courts, it's the people's. And that simple idea, which stretches from 1787 to this day, constrains public argument about the meaning of the Constitution and gives an advantage to those who convince the public that their interpretation is in line with the original meaning of the text. And this, I think, is what we as academics have to learn from the general public about originalism. At the end of the day, whatever our academic arguments about the impossibility of originalism, or the incoherence of originalism, or the injustice of originalism, the general public just keeps flying along like the bumblebee who, despite being told by the smartest people that what they're doing is impossible, just keep flying anyway. People accept originalism because they believe in popular sovereignty, and it's we, the proponents and critics of originalism, who have something to learn from that, something to learn from the general public, and not them from us. Thank you, and I look forward to hearing from Elizabeth and the rest of our panelists.
Thank you. Wonderful remarks. So thanks to the Federalist Society chapter for organizing today's event and this panel, and special thanks to Sophia Evans and Connor Kurtz for inviting me to speak on this panel. When I first saw the description for the panel, I thought, do originalists care what the public thinks about originalism? No, definitely not. But of course, what the public thinks does matter. The court draws its authority from the people through the Constitution. And it depends on the people respecting its legitimacy. And I believe a commitment to originalism is the best way to enhance the court's legitimacy. Now, that legitimacy depends on the public actually understanding what originalism is. And David is going to talk a little bit later about some of the current criticisms and how they get originalism completely wrong. But I want to focus on how originalism enhances the court's legitimacy especially in a time when we're told that there is a serious crisis of legitimacy due to a politicized court. So first, the court's authority is central to it being able to function. Its judgments are not self-executing. As Alexander Hamilton famously explained in Federalist 78, the judiciary can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment. So the court relies on others to enforce its rulings. And generally speaking, people have respected the court's authority. There are not that many instances in our nation's history of serious backlash to a Supreme Court ruling to the point of people refusing to obey it. Of course, there was the controversy over Georgia's seizure of Cherokee lands and President Jackson's infamous and possibly apocryphal claim that John Marshall has made his decision, now let him enforce it. And President Lincoln's showdown with Chief Justice Taney over suspension of habeas corpus. But looking to the modern era, these disputes have been few and far between. We all know that following the court's ruling in Brown versus Board of Education, President Eisenhower had to federalize the Arkansas National Guard to ensure the district court's desegregation order was followed. But more recently, looking at the court's ruling, for example, in Obergefell versus Hodges, we saw a few county clerks refuse to perform marriage ceremonies for same-sex couples, but there wasn't a large-scale effort by states to ignore the ruling. And even though the ruling was particularly unpopular in a good part of the country, it was respected. And so I think that tells us that legitimacy isn't the same thing as popularity. And likewise, we haven't seen states flat out ignore the ruling in Roe v. Wade, even though it has been hotly contested since the day that it was decided. So I think at the end of the day, people respect the court's authority. So this crisis of legitimacy we hear about is overblown. Turning to how originalism fits in with this, I think originalism enhances the court's legitimacy because it minimizes the opportunity for a judge's biases to come into play. We expect the court to issue rulings based on the law and the Constitution, not on judges' policy preferences or what they think justice requires. And I believe originalism is the best method we've come up with to do that. Is it perfect? No. Is there always a clear-cut answer? No. There's a great passage in Justice Gorsuch's book, A Republic If You Can Keep It, where he talks about how the alternatives to originalism often backfire. And I want to read a little bit because I think it's just really great. So he's talking about specifically about Dred Scott and Korematsu. He says, "Neither can be defended as correct in light of the Constitution's original meaning. Each depended on serious judicial invention by judges who misguidedly thought they were providing a good answer to a pressing social problem of the day." And then later he writes, "In both cases, judges sought to pursue policy ends they thought vital." So in Dred Scott, avoiding a civil war, Korematsu, protecting American safety during wartime. Back to Gorsuch. "Theirs was a living and evolving constitution. And often enough, it may be tempting for a judge to do what he thinks best for society in the moment, to bend the law a little to an end he desires, to trade just a bit of judicial integrity for political expediency. But as Korematsu and Dred Scott illustrate, the pursuit of political ends through judicial means will often and ironically bring a far worse result than anticipated, a sort of constitutional karma." Judges aren't oracles after all. And the fact that we have a written constitution reinforces that originalism is the best method of interpretation. Sure, cases could be decided by rolling dice. That would certainly eliminate the judge's personal biases, but that wouldn't be a legitimate method of deciding cases. Further, when people complain about originalism, I think what they're actually complaining about is the Constitution and its constraints. Originalism focuses on process, not on substance. And skeptics should look no further than law and order loving Justice Scalia's Fourth and Sixth Amendment jurisprudence for proof that originalism isn't outcome determinative. An important aspect of originalism is that it pushes back on efforts for judges to invent new constitutional rights and short circuit the political process. The Constitution was designed to leave a lot to the people. And I think that's why we hear it's so hard to amend the Constitution and we have to use the courts. But that's exactly the point. That's a feature, not a bug in the Constitution. It is hard to make change, whether you're talking about constitutional amendments, legislation, or just changing public opinion. It requires compromise and persuasion. Abortion, I think, is a great example here. Even Justice Ruth Bader Ginsburg acknowledged that the court went too far and too fast with Roe v. Wade. It short-circuited the legislative process. Had the issue been debated by legislators who are responsive to what are supposed to be responsive to what the people want, I don't think it would be such a divisive issue today, half a century later. And we certainly wouldn't have to hear about Roe v. Wade and super duper precedent at every confirmation hearing. So one final point that I want to make is how the narrative of a politicized judiciary fits in with its legitimacy. Politics today are polarized, and there's a lack of faith in many institutions. There is still a not insignificant number of Americans who think the election was stolen. And this is admittedly a much bigger problem than we're trying to address with this panel or this conference is trying to address. But I think the court has mostly weathered the storm well when it comes to charges of politicization. But there are some things that could help this along. So first thing, I think politicians have got to stop attacking the court in the way that they have. It's one way to disagree with a ruling on its merits, but it's another thing entirely when politicians make threats to pack the court and tell bald-faced lies about what justices might do. For example, saying a certain justice would be confirmed so that he or she would vote a certain way in a hypothetical election-related case. Let me walk through some examples. So standing outside the court about a year ago, after the justices heard a challenge to Louisiana regulation of abortion doctors, Senator Schumer had a message for Justices Kavanaugh and Gorsuch. He said, "You have released the whirlwind and you will pay the price. You won't know what hit you if you go forward with these awful decisions." A not so subtle hint that there would be consequences unless the court ruled the way he wanted. Similarly, Senator Sheldon Whitehouse and a group of his colleagues filed an amicus brief in the New York gun case last term, saying the court is not well and must heal itself or face restructuring. The path toward healing naturally would include ruling the way the senators wanted. And of course, President Trump leveled personal attacks against judges from the district courts all the way up to the Supreme Court when they didn't rule his way. And comments like these are part of the problem. Trying to harass the justices to rule the way you want doesn't depoliticize the court. It calls to mind something Chief Justice Roberts wrote in a different context. He once wrote that the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. And I think the way to stop the politicization of the Supreme Court is to stop politicizing the Supreme Court. And it's not just politicians' careless rhetoric that contributes to this. I think we must all respect the limits of the judicial power. We can't ask the court to update laws, discover new rights, resolve disputes between the political branches that they should work out on their own. The court is not a political institution, and the framers of our Constitution knew well that judges' independence from politics would be essential for our system of government. So I think the court needs to double down on its commitment to originalism. Several of the justices are at least part-time originalists. Justice Kagan was right, I think, when she said, we're all originalists now. And it's a judicial philosophy that people across the political spectrum have embraced. So to all the originalists out there, we need to keep explaining to people why it's the best method to guard against judges imposing their policy views on society, and that in turn enhances the court's legitimacy. I'm going to turn it over to David now.
Hey, thank you so much, Elizabeth. I should mention to the audience, if you're not already watching, you should check out her great podcast. I think it's in, the season's done right now, but that just means you can catch up on it. It's called The Dist, and it's a look at the great dissents of the past. It's really a lot of fun. I think my husband and I kind of binge listened to it. So anyway, you should check it out. So anyway, I feel I'm in a little bit of a tricky position as the last panelist of the last day. I feel that most of what I've said or was going to say has already been said. I've gone through my remarks and tried to call some things in light of things I heard from, of course, the earlier panelists here and even some of the prior panels I was able to tune into, but I apologize, of course, if there's some overlap between my remarks and some of the remarks that maybe I might have missed. So I come at this topic from a somewhat different angle. I'm not a practicing lawyer or a professor. I'm a journalist, a writer, and I can speak to the public understanding or misunderstanding of originalism. And I guess I'm a little less optimistic than Evan and Kurt. I do agree that originalism has great purchase within the judiciary, especially the Supreme Court. And I do agree that many members of the public intuitively agree with the originalist method. But I think originalism, the term itself, the O word, I think, well, to be blunt, I think it could use a new publicist. I think that there are a lot of misunderstandings out there about what originalism is, qua originalism. And I think that there's a huge gap between what originalism actually is, as the people who've tuned into this conference or symposium know, and what many members of the public think it is. I agree with Elizabeth and the prior speakers. Originalism really is, I think, the best method of interpreting the Constitution and interpreting our statutes. I think about it a little bit like how Churchill thought about democracy. It's not perfect, but it's better than all the other methods. But I think that out there in many quarters, originalism has been quite demonized. I think if you were to play a word association with originalism in some members of the public and ask them what words come to mind, I think words like strict, stringent, archaic, outdated, harsh, antiquated, I think those are unfortunately some of the terms that would come up in connection with originalism. So as Evan mentioned, I'm going to talk about some of the common misconceptions about originalism. And I thought, well, what better place to go in search of misconceptions but Twitter? So I actually went on Twitter and looked up various references to originalism and originalists, especially around the time of the confirmation hearings for Justice Amy Coney Barrett. And there is definitely a lot out there. In fact, there is a fun Twitter account, I think at Bad Originalism. It's entitled Bad Originalism Takes, where the author just goes around collecting tweets that propound misunderstandings about originalism, of which there are many. So here are a couple. And I think that, as Elizabeth just mentioned, as people who do understand it, it's incumbent upon us to try and educate our peers and other members of the public about what originalism actually is, as opposed to this caricature of it that's been painted. So I think the first I would say is originalism is all about strict constructionism. And in refuting this misconception, I would just quote the late Justice Scalia, who said, "I'm not a strict constructionist, and no one ought to be." He went on to describe strict constructionism as, quote, "a degraded form of textualism that brings the whole philosophy into disrepute." Instead, he said, a text should not be construed strictly, and it should not be construed leniently. It should be construed reasonably to contain all that it fairly means. A second misunderstanding, and this has been touched upon previously this afternoon, is originalism is all about original intent. Of course, as we all know, and as we've discussed extensively today, really originalism today is about original public meaning or original understanding, but original intent still really lingers. And to be fair, of course, earlier versions of originalism do talk in terms of original intent. Certainly the early writings of Professor Robert Bork speak in these terms. But since then, everyone who was an originalist, including Bork himself, has sort of come around to focus more on original public meaning. But again, if you go on Twitter, you'll find many references to original intent. Just earlier this month, Christopher Scalia, the son of the late Justice Scalia, tweeted out an excerpt from a New Republic article, which described originalism as, quote, "the conservative theory of constitutional jurisprudence that declares that only the literal meaning of the Constitution's text, along with what we know about the intent of the founders, can guide the courts when they interpret laws." Of course, as Chris Scalia correctly notes, this hasn't really been the vision of originalism for more than 30 years. But again, it still makes its way into the pages of prominent publications like the New Republic. Or take this tweet by Senator Ed Markey of Massachusetts from during the Barrett confirmation hearings. "Originalism is racist. Originalism is sexist. Originalism is homophobic. Originalism is just a fancy word for discrimination." And that tweet by the senator has 23,000 likes. Now, of course, we all know Twitter is not real life, and it's definitely skewed towards a certain perspective. But there are definitely some people out there who subscribe to some kind of misguided or twisted vision of originalism. It's funny, I actually thought Evan was joking when he referenced this Cosmopolitan article about 9 reasons originalism is BS, but sure enough, I Googled it, and there actually is this article, around the time of the Gorsuch hearings, 9 reasons that originalism is BS. It shares website space with 17 best at-home hair dyes that look totally natural. But yes, there is this article, and in fact, point number 5 in the Cosmo article is consistent with Senator Markey's tweet. Originalism is a cover for legal discrimination. But again, I think this tweet or this misconception illustrates the problem with original intent versions of originalism. What essentially casting originalism as original intent does is it allows the critics to basically go inside the subjective minds of the founders or the people who passed a particular law or provision, find objectionable beliefs such as a belief in slavery or the inferiority of women, and then dismiss the entire originalist enterprise. And as we all know, that is really not a legitimate criticism or argument of originalism. So this misguided focus on intent, I think, leads to the next misconception of originalism. And I would describe it as originalism is some sort of magic time machine. Again, here's a tweet from another Democratic Senator, Chris Murphy of Connecticut. He tweets, "Women couldn't vote. Slavery was legal, but originalism." And that tweet, sent out during the Barrett hearings, has 25,000 likes. And essentially what it's trying to say is, well, originalism means looking back at the original meaning of this document. And so therefore we have to take the entire society back to the time when the document was propounded. And so therefore, suddenly now we're back in a time of slavery and a time when women couldn't vote. But there's a very simple flaw to this vision of originalism. It ignores all of the subsequent amendments to the Constitution, including the post-Civil War Reconstruction amendments that Cert talked about earlier. And so the original Constitution, even though, of course, it had its flaws, at least contained within it the mechanisms for its own improvement and perfection. And so again, I think this vision of originalism as this time machine that takes us back to a time when everything was so much worse is really, again, just a twisted version of the doctrine. And amendments are a really crucial part of the originalist enterprise. Justice Scalia himself was very fond of telling people who disagreed with policy outcomes of his rulings, look, if you disagree, go pass a statute or go get the Constitution amended. And there's nothing wrong with that. In fact, it's far more legitimate than trying to twist the text of a clear provision to get what you want. Instead, just get it amended. And there are lots of examples of this. Justice Ginsburg's dissent in the Lilly Ledbetter pay case led to a statutory amendment. And again, that was entirely legitimate to do that. Amendments are an important part of this process. And then I guess the final critique of originalism that I think is misguided, and it shows up as reason number 4 on the cosmopolitan list, is originalism is incapable of dealing with modern technology. And it flows naturally from the prior misconception about originalism as a time machine. And it basically simplistically holds that originalism is somehow incapable of dealing with any technology or phenomenon that was not around at the time of the founding or that was not around at the time the relevant amendment was passed. And again, we originalists know that that's not the case. Justice Gorsuch explains this well in his book, which Elizabeth quoted earlier, A Republic If You Can Keep It. He writes, "Originalism teaches only that the Constitution's original meaning is fixed. Meanwhile, of course, new applications of that meaning will arise with new developments and new technologies." And he gives a good example. He talks about the 8th Amendment's prohibition on cruel and unusual punishment. And he talks about how that provision, in the eyes of an originalist, would absolutely be triggered if you decided to torture a prisoner using a laser, which wasn't in existence at the time that the Bill of Rights was passed, but would very much violate the 8th Amendment. So again, originalism is not stuck again in amber and incapable of dealing with things that didn't exist at the time of the founding. Another good example is the Supreme Court's 2001 decision about thermal imaging technology, where the court, in an opinion by Justice Scalia, really the greatest originalist of recent memory or not so recent memory, the court held that essentially aiming a thermal imaging device at somebody's house would constitute a search within the meaning of the 4th Amendment and would therefore require a warrant. And again, thermal imaging was not around in the late 1700s, but originalists understand that the word search in the 4th Amendment can include new types of searches made possible by technology that didn't exist back then. So originalism really is fully capable of dealing with new technological developments. Another very good example, of course, that's going to, I'm sure, come up even more is just social media. Again, if you go on Twitter, you'll see people citing the existence of social media and suddenly thinking that they've refuted all of originalism. That's not the case. We all understand that the words of the First Amendment and the protection of freedom of speech do apply to different forms of speech, including speech over Facebook or Twitter or Parler or Pinterest or wherever you are. And so again, I think a correct understanding of originalism recognizes its ability to deal with new and modern technologies. But I do think that all of these misconceptions make clear that for those of us who are sympathetic to or supportive of originalism, that our work is very much cut out for us. And I think we need to do all that we can to clarify respectfully and in good faith a lot of the misunderstandings that are out there. Thank you.
All right, thanks so much, everyone. That was fascinating. Although I really can't believe that David thought that I had made up a Cosmopolitan article. What slander am I being accused of here? I remember that article vividly because Professor Michael Ramsey posted on it on his Originalism blog, saying that he never expected to see the day when we would have public commentary from Cosmopolitan about originalism. So yeah, no, that was an article. That's why I gave the date. But notwithstanding that, so we already have some really good questions. But before I delve into them, I thought we would just open it up a little bit to talk about some of the responses that we had to one another's presentations, if any, unless you just completely agreed with everything that everyone said.
I'll step in if that's okay, because in terms of whether or not, this is a response to David, in terms of whether or not, we are too optimistic about the general public, I agree with you. I agree with you that we need to be attentive to how things are being portrayed in important opinion-making media outlets, because those can have an impact. Ultimately, those can have an impact on the general public's understanding. I nevertheless remain optimistic in the sense that I think the conception that the Constitution is the people's and not the courts, and their presumption, the presumptive acceptance of historically based understandings have gone on for so long and are embraced in a bipartisan way by both Democrats and Republicans when they see an advantage, right? When they see an advantage to do so, does make me optimistic that originalists will always get a good hearing if their voices can cut through the din and actually explain themselves to the general public. But that does not at all absolve us of needing to work through theoretical difficulties and give answers where answers are due. So I agree with that. I do.
I'm impressed that David waded into the thicket of Twitter to see what people were saying about originalism around the time of Justice Barrett's confirmation hearing. I'm sure it was illuminating.
It's a tough job. Someone's got to do it.
I'm surprised that David thought that I was optimistic, quite frankly. I tried to draw a distinction between what I think really is originalism's ascendancy, even within the academy, passe Cert about that, and the public's response to originalism. I'm aware of those Twitter criticisms, and I do think that the sociological legitimacy problem is a real one. I mean, just some of the polls that I've looked at lately about responses to the courts, it's kind of surprising to see that, one poll that I looked at, 40% of those polls favored court packing and saw it as a legitimate tactic by way of they would not call it trying to change the political composition of the court so much as preventing a politicized court that has been captured by Republicans from being mobilized in a way that undermines progressive interests. I mean, these claims can be rejiggered in ways that are not seen as so overtly political if you just frame them as, well, we want methodological diversity on the courts. We want to ensure that it doesn't become further politicized, et cetera, et cetera. And that really leads to what I think is the first question that I got here really ties directly into that. How can we explain originalism's role in preserving judge neutrality in situations where we only have a minute to make a point, especially to people who view originalism as purely a Republican tool? Who wants to take a crack at that one?
I'll bite. I think it's helpful to point to the variety of originalist opinions that are out there, and that they don't always reach conservative outcomes. You know, I know that we've already talked a bit about Justice Scalia and the Fourth Amendment, but I think that's a prime example. It's not an area where what you might expect his personal views, you know, they certainly would not support the outcome that he found, you know, when he dug into the history to answer questions in the Kylo case, the thermal imaging case, or, you know, any of the more recent ones like the GPS tracker case and so on. So I think the best thing when you have a limited amount of time is just examples. And, you know, you can point out that Justice Stevens had an originalist rebuttal to Scalia's originalist opinion in Heller. And you can point to examples of Justice Kagan embracing originalism. There are also examples of Justice Ginsburg. I think there was an election-related case out of Texas several years ago that people say that, you know, maybe the Evanwell case. Yeah, so that, you know, maybe we can quibble over whether they were doing originalism right, but, you know, I think that's the best way to push back when you have a short amount of time is to show that there is a diversity of opinion even within originalism.
I guess another question that I would just say, if you have to deal with sort of, you know, a quick sort of response, is just, what's the alternative? I just don't really know. Everybody likes to say, oh, well, we really believe in the, you know, living, breathing, you know, stairmastering Constitution. Like, oh, it's so great. But I mean, how do you decide what goes into that living Constitution? Whose vision? And this is where I agree with Elizabeth's point about just trying to cabin judicial bias and discretion. I just don't know what the alternative is. If you ask, well, okay, you don't like originalism, so what's your vision? And then they go on for like 20 minutes, like a Justice Breyer book. Like, it's very hard to come up with a cogent, concise, alternative method of interpretation to originalism. And I think if you ask people to try, they'll fail.
David, I think you mean like a Justice Breyer question. As opposed
that
to
too.
You know, Evan, when you asked that question, my first thought, I thought both of Elizabeth and I thought of David. I think that question reflects a misconception about originalism. And my response would be to say something along the lines of what Elizabeth said about legitimacy. It reflects an instrumentalist approach to originalism. In the sense, you want originalism to create neutral judging. It's going to constrain judges, and it's going to prevent them from filling their subjective preferences into the Constitution. And so it's kind of we need to control the Warren Court, and that's why we're originalists. And I don't accept that as a normative vision or a normative justification for originalism. I don't adopt it regardless of whether or not it's true, regardless of whether or not normatively it's attractive. I'm just adopting something that will allow me to put some type of straitjacket on the court. That's not, for many of us at the very least, and I think for most people, that's not what originalism is. Originalism is a theory of what the court should be doing. Now, maybe they won't do it, but they only have legitimate power to say what the law is, and the law is the people's constitution. The people are the ones with the authority to set the fundamental rules. And so what I'd say to them is, originalism isn't guard and to ensure judicial neutrality. Originalism is simply what you do when you uphold the oath to follow the people's constitution, and the court doesn't always do it, and they should be held up to criticism when they don't do it or when they're inconsistent. But we don't purport, I don't think originalists purport to have come up with a theory that ties down the judge and ensures.
No, I should clarify. I agree with that. I think we are originalists because it's the right way to interpret the Constitution. But I think that one of the things I think we're touching on a little bit in this panel, to be kind of, I don't know if this is too cynical a term, but like marketing, or as one of the Q&A questions says, rebranding. And so if we're sort of talking about how do we sell originalism after first explaining why it is the right and proper and moral and ethical thing, then we need to kind of be like, oh, and here's this other thing you get. It's like trying to sell, like, the knives, like, oh, well, they cut really well, but also they're safer. Like, you kind of have to come up with other benefits. I mean, even if you're just trying to do the internet thing of a listicle, you can't just be like, one really awesome reason originalism is the best method. You need like 5 reasons or something if you're going to make a Cosmo article out of it. So I think that cabining judicial discretion could be one, obviously number 2, and far behind in importance to the fact that it's really the right way to do things. But it's kind of funny, like, so there's that question in the Q&A, which I thought was a good one, but a tough one. If you were tasked with rebranding originalism, what would you call it? And I actually don't know that I would give it a new name, because I really like originalism and I kind of want to just make everybody understand why it's great. But like, if I had to come up with a term, it would be something that kind of sounds ridiculous, like meaningism or something. Like, well, we should give statutes and constitutional provisions their like meaning. Like, it just is very strange. I mean, it just kind of underscores what's the alternative to this. And I mean, it starts to sound like something out of Alice in Wonderland or something. But so I don't know that I would necessarily give it a new name. I think I would just try to point out the difficulty, if not futility, of trying to come up with some other method.
There was a time in the academy when what we would now recognize as originalism in some embryonic form was referred to as interpretivism. So baking into the very notion of interpretation following original meaning. It didn't catch on, and eventually
Right. No, I know.
a lot of the discourse. By the way, that question was by Jacob Smith. Jacob, I'm sorry I didn't give you credit. There are a couple of Jacobs in the Q&A here, so I don't want to get them confused. Interestingly, we answered the first Jacob's question, Jacob Smith, then we got into Jacob Marsh's question. So we're going to move on from the Jacobs. And Elijah Coriel asks Elizabeth Slattery, or any other panelist, in terms of enhancing the legitimacy or popularity of originalism, how important are originalist opinions that cut against conventional conservative thinking on a particular issue? You might think that we touched upon this, but then I'm thinking of Justice Gorsuch's recent opinion in Bostock is a prominent example, which is, I think, a challenging one for a bunch of reasons. So let's open it up to that. What would you say to Elijah?
Yeah, so the Bostock case, that's a challenging one. Of course, I think there was a whole panel on that case this morning, and that dealt with dueling visions of textualism, which is basically originalism for statutes. And Justice Gorsuch's approach was, do we take a literal approach to what words mean if they're clear? And then Justice Kavanaugh took a different approach, which was more, I think, tapped into common sense. And we look at the plain meaning and what something was understood to mean at the time, at the time that it was adopted. And so, I thought that opinion definitely was a discussion starter for a lot of people, and maybe a way to draw people into to our side of textualism and originalism. But it does highlight the fact that there's a diversity of views and a diversity of ways that justices approach textualism and originalism. Whether that I think that maybe does help with its legitimacy to the public if they see that it doesn't always result in lead to results on one side of the aisle. But yeah, that one was kind of a head scratcher for me.
I totally agree with Elizabeth. I do think that it's, and with the premise of the question too, I think it's very good just in terms of selling originalism when you have these rulings where either originalists can disagree or originalism goes against what is viewed as a conservative or Republican outcome. Because I think it makes clear to people that originalism is actually a methodology. It's not just some vehicle for imposing Republican or conservative policy preferences on the law. So in addition to Bostock, which was an interesting debate, and Alito saying this was like the ship flying the pirate flag, there are a lot of other, Justice Scalia was very fond of talking about originalist opinions that didn't really cut his way. So all of his Sixth Amendment jurisprudence, Justice Scalia wasn't exactly well, actually, he kind of did say he was, I was going to say, he wasn't exactly a friend of, criminal defendants, although I think in his later years, he liked to call himself the pinup or poster boy for criminal defendants or something after all of these various decisions. But, he was a law and order kind of person, probably in his policy preferences, but he was totally fine voting in favor of criminal defendants when originalism took him there. And I think that that's very burnishing of the legitimacy of originalism to show that, look, it isn't just this machine that spits out Republican outcomes. Now, I've heard some critics of Scalia say, well, and this is sort of circular on their part. They would say, well, he just didn't care that much about criminal law. He only, that was like his little sop. And really, on the things he really cared about, like abortion or gay rights or something, he was just a cover for his policy preferences. But I don't know how you can come up with that. I mean,
or that he was actually more libertarian than we thought he was.
Right.
The author of The Dissent in Lawrence was a libertarian. Yeah, I have the same reaction.
Again, just quickly here. Again, we're discussing originalism through an instrumentalist, lens, in the sense it'll get. Hey, be an originalist. Just wait till you see what it'll get you. You won't believe number 3, and jump down into it. And that I suppose it is important to try and explain that it's not a right-wing Federalist Society conspiracy to bring Roman Catholicism. I'm trying to remember what the most recent article says about originalism. And in that regard, I think that Lawrence Solom, again, has done some really good work. Surprising Originalism, I think, is an article that he just wrote showing how originalism in different ways falls across the ideological spectrum. And I agree that that's helpful. For me, it's in some ways academically, it's an odd argument, because I grew up in the era where the people who were pushing originalism and pushing the historical investigation of the Constitution were people like Bruce Ackerman and Akhil Amar, who just are not conservative Republicans, okay? And their point always was that the invocation of liberty and the understanding of liberty is surprisingly progressive if you just give it a chance, if you just investigate what exactly they were trying to do and why they were trying to do it. My own work pushes against conservative rejection of incorporation of the Establishment Clause into the 14th Amendment. I believe it very much was a new idea of non-establishment. And so the actual history, we go through periods where the debates don't cut at all according to current political divides. So I think it's necessarily the case that we are going to be surprised. We are simply going to be surprised when we engage constitutional argumentation at the time of the adoption of these various amendments. So this is another place where I think scholars can help answer that claim that you have become an originalist because you're instrumentally trying to find something that will always give you a win, or join our side. We'll get you more wins than you think you're going to. It's just that what we do and what originalism is orthogonal to current ideological debates, and those debates themselves will shift. And libertarianism and state, the legitimacy of state resistance, okay, is going to change from Democrat to Republican administration. But scholars, and I guess my only point is scholars can also play that role in showing how history itself is surprising and doesn't cut across ideological lines.
Justice Scalia loved the word orthogonal. He inspired a commentary during oral argument at one point on orthogonal. Ooh, he liked that. That's a compliment, by the way. So it sounds like, Kurt, just to follow up on that, you would reject the premise of a question from a conservative who would be inclined to complain about originalism failing to deliver the substantive goods that inspired conservatives to become originalists in the first place.
This would, I'm not sure, but
So,
I hear some of those arguments from
in connection with Bostock, and some recent articles have been published criticizing originalism for failing to deliver the kinds of outcomes that social conservatives want. It seems like what you're saying is that that kind of thinking about the role of originalism really does miss the point, both in respect of its value and in respect of its legitimacy.
Yeah, it's a legitimate criticism, but it reflects a very different normative theory of constitutional interpretation. And I would associate its most cogent articulation with Adrian Vermeule's idea of a common good constitutionalism, where you would want to adopt an interpretive method that advances human flourishing, and there are different theories of human flourishing, and the common good, and that if originalism, however you define it, is not advancing human flourishing, if it's not advancing the common good, then it should be abandoned. And from that perspective, from that normative approach to a constitutional regime, he's right. Yeah, get rid of it. That's not why I'm an originalist. I'm an originalist because I'm a popular sovereigntist. I still believe in the normative good of allowing a supermajority of the people to instantiate their will through the device of a written constitution. I think it's an astonishing invention, a wonderful invention that's worth continuing to pursue, but it never gives you that option to simply jump off the ship, jump off the we the people constitution, simply because what we the people did doesn't advance human flourishing. So my response to them is that you've got a normative theory. Okay, let's see whether or not I can convince you that the normative theory of popular sovereignty is better, and I could lose, but it does reflect a different theory.
Great. Okay, let's see. Do we have any more questions here?
So there's one question about whether the court should grant cert in more cases that might cut against a conservative policy preference. And I just want to say, I think the court should grant cert in a lot more cases, whether or not they are cases where there's that at stake. But I think the court getting down to about 70 cases a term with as many law clerks as they currently employ, compared with in the 80s or even further back, they were routinely hearing 150, 200 cases a term. I think we'd see, the justices maybe labor over each case less. We wouldn't have 100+ page collections of opinions between, although this goes against my professional interest in dissents, but we'd see a lot less laboring over every issue. And I think that, it might be good for the country if the court was more actively involved in managing the judiciary in that way.
Great. Let's see. How does the court guard its legitimacy in an increasingly more populist landscape? Will the current populism trends find a way to embrace originalism? Anybody want to take that one on?
I think that speaks to what Kurt was saying, honestly.
Well, I'm not sure how. I mean, I'm happy.
No, but I think that if you believe in popular sovereignty, then why wouldn't the populism embrace originalism? But not in terms of policy outcomes. It's more of a deep-seated kind of belief in rule by the people.
Okay, thank you, David. That's a great point, and I guess I come at this with too much Bruce Ackerman in the back of my head that I don't really bring forward. by popular sovereignty, I'm talking about the unique approach of the American Constitution of divorcing ordinary politics from constitutional politics. And the voice of the people only emerges out of a special kind of constitutional politics, not ordinary populist politics. And so how do you identify when the people have really spoken? Well, that's a hard thing, and maybe we've gotten it wrong. But one way is to not identify it just with legislation that passes by a 50% rule, maybe not even legislation that passes by a 2/3 majority. Let's make sure that this is a really thick, considered idea of the people themselves. So let's require 2/3 to even start talking about it through a proposal, and then it doesn't get ratified until 3/4 of the people actually consent to it. It's not a perfect form of identifying the people, but it results in something which has a greater claim to representing the will of the people than ordinary politics. The one-time election of Donald Trump, or the one-time election of Barack Obama, or whatever it might be, or whatever the current politics are on the Hill. That kind of populism cannot claim to be the popular will in terms of American constitutional popular sovereignty. So I would divide the two and say that the populism has to work within the Constitution that we have. And if current populism, however defined, wants to entrench itself, if it thinks there's something about the Constitution that needs to be changed, it has a lot more work to do than just winning an election or two.
It can manifest itself through amendments. Like if there's enough populist belief in something that we need to amend the Constitution or amend statutes, well, then I say, God bless. But, just going by opinion polls or something and saying, well, this opposition to immigration seems popular, so therefore let's interpret it this way, like that, I don't think any of us would take that as legitimate.
And notice how for me as an originalist, that explains why I would embrace originalism as opposed to a living constitutionalist approach, which would not oppose being informed by popular movements, and would not, whether popular movements internationally or popular movements domestically, or even popular movements that have been constrained and directed by the opinions of the court itself. The decisions of the court can shift and change the way popular politics takes place. Originalism resists that. Popular sovereignty insists that no, none of those popular movements has earned the right to be entrenched as the will of the people themselves. And so rather than a living constitutionalism that would look to polls, right, or whatever the thing might be, it's always backwards looking. It's always backwards looking at the last extraordinary moment when this supermajority of the people entrenched their will.
Okay, I think we are done with the Q. We have a very interesting question about the work of historian Jonathan Gynap. I think it may be a little bit abstruse for the setting, but Joe Rooney, good on you for asking it. Gynap's work is very stimulating and worth thinking about. And I would commend it to anybody who is still watching this at this point. Question for you guys from me. How has originalism changed over the years since you were paying attention to such things? And if so, how? If so, have the changes been positive or negative?
Well, we've certainly seen, a transition from, from the 70s and 80s, the original intent focused, and with, time and scholarship, originalism has further developed into original public meaning originalism. And, there have been new sort of innovative ways like the field of corpus linguistics to try to come up with new ways to figure out what that original public meaning was. And so I think, corpus linguistics is one of the more exciting and interesting developments in originalism. Shows how exciting my life is.
I'm the old guy here, right? So I've seen a lot of winters, and I've seen a lot of things come and go. And again, there have been remarkable changes. I actually think that what we call originalism today, back when I was first entering the academy, would be called the Republican revival. an enormous body of scholarship that was looking back to the time of the founding for basic philosophical principles that should inform the original Constitution and the New Deal Constitution. So it was very historically oriented interpretation and application of the current Constitution. Since that time, of course, we've gone through all kinds of moments. There was a 10-year period when originalism was dead. It was vanquished. Paul Brest and the rest of them just killed it. There was no way it was going to recover from the attacks on original intent originalism. And it goes dormant, for a while, and then it reemerges. Probably, I think Scalia might have played an important role here, but a lot of people played a role. When it reemerges as public meaning originalism, it finally found its legs, and it has exploded into this multi-varied, multi-theoretical area with whole schools of thought that are arguing with one another, which I think to me some people say that's why it's pointless. To me, that's a sign of a very healthy theoretical approach that's worthy of deep investigation. And that's just a remarkable new period that wasn't on the horizon when I first started.
And I think part of that, in large measure, can be credited to the work of the Federalist Society, bringing people to
That's right. That's right.
To law school campuses, and generations of lawyers today came up, thinking this was a perfectly legitimate way to approach the law, whereas before the Federalist Society and in the early 80s, it was not mainstream at all.
I agree. Yes.
So the last question I think we have time for, this is another one I'm just going to take moderator's prerogative with. Is there an argument that originalist defenders tend to make that you wish they would stop making? And why?
David, the defenders make.
David, that's
pretty much all the instrumentalist arguments is what Cert would say. But this is a bit of a digression, but if you just think about even just the backdrop of philosophy, utilitarianism is so much easier to explain than pretty much any other type of philosophy. It's something that accords with people's common intuitions. Like if you ask me to explain Kant or Rousseau versus utilitarianism, I can easily explain utilitarianism.
Nobody wants you to explain Kant. Don't worry.
But yeah, I don't know what is a bad argument. I don't know. The argument about, it's going to give you all these policy goodies. I guess even I don't like that argument.
Mm-hmm.
Well, I think the only thing, I actually think defenders, I think the argument's going very well. I think it's a very robust argument. I think people who are criticizing originalism, just saying it's impossible, it doesn't work, they really are minority voices. The debate is going on very well. The argument that I think is least successful, and I don't even know that many people who are doing it, but it's that argument that it will constrain judicial adventurism, and that originalism will finally make judges behave. That really was an argument on the table a while back during the development out of the Bork writings era. But it's so easily blown apart, right? By simply showing, look, here are two originalists and they came to two different understandings. And so clearly you can just choose your originalism. And so there's no constraint on justices whatsoever. So it's an easily disproven argument in favor, or at least rebutted argument in favor of originalism. But honestly, I hear that argument more from critics who are setting up a straw man than actual proponents of originalism.
Okay, I think that is all that we have time for. Thanks to all the panelists, and thanks to UVA FedSot for making this happen. Thanks to you in the audience, all 40, 39, 38 of you who are still here at the end of a very long day. This has been a tremendous pleasure for me, and I hope you've gotten something out of it as well.
Thank you, Evan.